I had a preliminary hearing case for felony possession of drugs. My client was driving a car that did not belong to her. The police pulled her over. They suspected that she was a target for potential drug possession, and they pulled her over, took her out of the vehicle, and searched her car. Underneath the driver's seat, there was a box. The box contained various different types of narcotics and drugs. It had some cocaine, it had heroin, it had Molly, it had several other different things. My client did not speak with the police. When we went to the court date, there was an offer to plead guilty to some of these drugs. Because my client had not made any statements saying that she knew about the drugs or that the drugs belonged to her, we challenged any possession in the court. In order to be convicted of possession of cocaine or drugs or any other type of things, they have to show that you knew that the drugs were there. The evidence by the police that the drugs were simply in the car was not enough to go forward with any sort of drug prosecution. The judge heard all of the evidence, did not hear any evidence that my client knew about the drugs or were in her immediate possession, and he dismissed the case. This was a big win considering that we were looking at 5 different felony drug possession charges. So this goes back to a very important thing that you have to remember whenever you're stopped by the police: do not talk to them. You have the absolute right not to talk to them. And in this case, my client's refusal to talk to the police saved her case.